about equitable interest and remedies. Now, as opposed to legal remedies and legal interest. So now there are two types of interest in land: legal and equitable. Legal and equitable. So in this short video, I will use a lot of examples. The first example, of course, will be land ownership, because this is the biggest interest. Later, I will talk about leases, I'll talk about trusts, I'll talk about easement, meaning other major land interests. Now, let's talk about ownership first. You go out and buy a house. Before you go for your legal completion, you're not the legal owner yet. Meaning in the title registry, your name is not there. The legal owner is still the seller. So then what kind of interest do you have in land? So basically, what you have is not recognized by the land titles office, but is recognized by the court. So this is called equitable ownership. Now, example of an equitable ownership will be after you have paid for the option fee, for example, and then before legal completion. So in the interim, your interest is recognized by the court, the court of equity. Equity means justice and fairness. Now let's use a new home purchase as an example to understand how an equitable ownership, how an equitable mortgage eventually become a legal mortgage and legal ownership. Now, say you go to the showroom, you put a 5% booking fee. Of course, obviously, you're not the legal owner yet. What you have, of course, is already a position to continue to buy. Now, 3 weeks later, you exercise, you put down another 15%. 5 weeks later, that means altogether 2 months already, you enter into the legal contract, legal sale and purchase agreement. Now, you're still not the legal owner. Now, TOP later, temporary occupation permit, that will be 2.5 years, 3 years later from the point you put that 5%. You take the key, you go inside the unit, you are still not the legal owner. A year later from TOP will be CSC, Certificate of Statutory Completion. Now that will be issued to the building, the project. After that, about 3-4 months later, the seller, which is the developer, will notify you to say that, okay, I'm ready to go for legal completion with you. Now it's only upon legal completion then you become legal owner. So in the interim, that 3-4 years, if you sell the unit, it's considered sub-sale. That means it's still an assignment of contract. You're not the legal owner yet. Now, so on the day of legal completion for the new home, then the mortgagee, the bank that lend you the money, from equitable mortgagee during the interim period of 3 to 4 years, from equitable mortgagee, they will upgrade to legal mortgagee, meaning the bank's name will be inside your title. Now, of course, then you yourself will be the legal owner. Now, let's look at other types of land interest. Say somebody give a promise. A promise is also called a covenant. Let's say he gives the neighbor a promise not to build taller than the neighbor. Now, this one, I will have other videos. So you're going to search for the video in the same folder because I got graphic explanation whether this is driveway, whether this is height and all that. Okay, so there's some clip up there to help you understand the concept. So so somebody promised the neighbor that I will not build taller than you. Now, so this is a restrictive covenant. Now, from this restrictive covenant, a land right is created. So if I promise you not to build taller than you, then the land right is created in your favor. That is your land right against me. So that kind of land right, which is a height restriction, arising out of a restrictive covenant, is a restrictive easement. Now, it's also known as negative easement, meaning I cannot block your light. for example. So now, so what happened? The two parties, if they go into a deed and then they register the deed, so meaning my neighbor's interest will be shown in my title. So that is called a legal interest in land. Now, but now this kind of situation, mostly they will say, never mind, just gentleman agreement. But if let's say the other side say, oh, better play safe, even though we never go into a deed, I can lodge a caveat against my neighbor because this is proprietary in nature. So therefore, you can lodge a caveat. Now, if the affected party doesn't appeal, doesn't object to the lodgement of caveat, then the caveat will stay. So again, for caveat, I have related video also. Another big interest in land is called a lease. A lease. So a lease can be a legal lease. Leases exceeding 7 years must be registered with the Land Titles Office. So it's considered a land subdivision. So a separate title will be issued to the lessee. So I have a video on subsidiary certificate of title that will explain further. So now what happened is that sometimes people rent for 10 years. Now that is a very long interest. So the lessee rent for 10 years, but for some reason, they don't want to register the lease. So as a result, SLA, Singapore Land Authority, will not recognize your lease interest. But does it mean that then it's illegal? No. The court will recognize. Because the court will recognize the terms in the contract as being the lessor lease or let premises to the lessee for 10 years. So then the lessee has the right to use the property for 10 years, of course, on a certain fees. Now, so that is called equitable lease. While the government doesn't recognize, but the court recognizes. So now how often do we see this? Okay, you got 10 years cinema lease, you got factory lease on private factories. So it's not really very rare. Okay, so it's just once in a while you have some court cases to show you example of equitable lease. Now, one very big example of equitable interest will be the beneficiary in the trust. Now, so in the trust, the trustee or the trustees are the legal owner or owners. So they may be one trustee, they may be three. So some charitable or public trust or religious trust will have 5. So, okay, now, so of course, the rule says that the trustee is the legal owner. The beneficiary is just an equitable owner. Now, so somebody has kind of looked after the title on their behalf. Now, so, but the beneficiary actually possess the proprietary interest, that means the land right in the land. So now in the day-to-day examples, what we always see is guardian say parents pass away leaving behind properties for their minor children. So then the uncle or auntie will step in as the trustee and the guardian. So so that kind of trust, you will see that the beneficiaries eventually become will eventually become the owner when they reach 21 years old. But there are other trusts where the beneficiaries don't become owner. So we want to distinguish these two. So one is a legal ownership, the other one is an equitable ownership. Now, so sometimes parties sue each other, so they go to the court to seek the court's declaration. Okay, the example, I have 4 examples for you. So sometimes the dispute over real estate, the court, very difficult for the court to say, okay, you pay him 1 million or you pay him 300,000 and all that. No, that's called legal remedy. But usually the court will just look at the situation. So, and equity will then intervene. Equity means justice and fairness. So then they will rule according to what they believe is just and fair to the parties. So resulting trust. Now, the person who give money for the purchase of a property, but his name is not in the title. So sometimes you have this kind of quarrel going to court. So say, for example, if me and my sibling, let's say I put 70% of the purchase price and my sibling only put 30%, for example. So one day my sibling just unilaterally sever the joint tenancy. And once you sever a joint tenancy, it's 50-50. So that means now my sibling is holding on to 20% of my financial contribution. So I will go to court to seek a declaration that this 20% that is being retained by my sibling actually is mine. So I'm the beneficiary. He is the trustee of a resulting trust. Now, resulting trust refers to purchase money, purchasing money. So the court may say, okay, please return the 20% of the sale price to Sam. So now in the interim, before the money comes back to me, I'm the beneficiary of a resulting trust. So in the example, my sibling is a trustee, I'm the beneficiary. So constructive trust is somebody cheated your title. So example, a bungalow owner say, okay, I want to subdivide my house into maybe 4 terrace houses. So then get a contractor come in and then go into partnership and all that. So eventually the other party never returned the title to me. So then I go to court to sue. So the court say, no, you must return 2, maybe 50-50. You must return 2 of the titles back to Sam. So then in the interim, before the titles come back to me, so the other guy is a constructive trustee. I'm the beneficiary of a constructive trust. So one is a legal owner, the other one is the equitable owner. Now, injunction is another example. Now, take for the earlier example, I say, oh, I promise not to build taller than my neighbor. And one day I just decided to just breach my own promise. Then I go URA to apply for the permission to build, and URA granted because there's no record, right? So let's say it's just no record one. Now, so what happened? Now my neighbor will quickly go to court, go to high court for that matter, to get an injunction to stop me from breaching my restrictive covenant. So basically, injunction is a stop order. So the stop order is to stop me from building while the court investigates. Now, specific performance, the court can order a contracting party in breach of the contractual obligation to perform the contract. So equitable remedies, basically the judge will have to ascertain, was there an intention at the point when these 2 parties struck a deal, was there an intention for them to enter into the contract? So of course, somebody back out later. Now the court doesn't care. It's at the point when you went into contract, do you have the intention to go into the contract? If it's yes, and the other elements of contracts were present at that point, so the court will say, sorry, the party in breach, please, you cannot back off. Please continue to perform the contract. So that is called equitable remedy. Equitable remedy. Now, so these are all the related concepts. I have used like easement as an example. I've used option to purchase as an example. So please search for the video in the same folder to help you clarify, all right, anything that you don't understand. So thank you very much. See you in the next video.